wrong one. The report was circulated. It's taken as read. Let's go to corrections. Any corrections on page 1? Page 2? Can you go down? Page 2? Page 3? Page 4? Page 5? Page 6? Page 7? Page 8? Page 9? Page 10? Page 11? Page 12? Page 13? Page 14? Page 15? Page 16? Page 16? Page 17? Page 18? Page 19? Page 20? Page 21? Page 22? Page 22? Page 23? Page 23? Page 24? Page 25?
Recording in progress.
Page 26? Page 27? Page 28? Page 29? Page 30? Page 31? Page 32? Page 32? Page 33? Page 34. Page 35. Page 36. Page 37. Page 38. Page 39. Page 40. Page 41. Page 42. Page 43. Page 44. Page 45. Page 46. Page 47. Page 48. Page 49. Page 50. Page 51. Page 52. Page 53. Page 54. Page 55. Page 56. Page 57. Page 58. Page 59. Page 60. Page 61. Page 62. Page 63. Honorable Nevo Trochen.
Thank you, Chair. Page 63, 18.32. The committee requests to be updated, or the committee requests to get updates. So it must be
Yes. Thank you very much, Honorable Nevo.
corrected. Thanks.
Yes, that's fine. Thank you very much. 63, 64. 64, 65. 66. 67. 68. 69. 70. Thank you very much. Is there a mover for the report to be adopted as corrected? Honorable Nevo Trochen.
I move for the report to be adopted, Chair.
Honorable Nevo Trochen, move for the report to be adopted. Any seconders?
I second, Chair.
Honorable Janji seconds. Any objections? No objections.
I third say the adoption.
Okay, Honorable Glenis Breitenbach.
Thanks, Chair. We reserve our position.
The Democratic Alliance reserves its positions. The report is agreed to. Thank you very much. Let's go to the Land Court Bill. As we know, honorable members, that we passed the Land Court Bill last year. It came back from the NCOP with amendments. It's a Section 75 bill. We can either agree to the amendments or not agree to the amendments as the NA. The Deputy Minister will take us through the proposed amendments as proposed by the NCOP. Over to you, Deputy Minister.
Thanks, Chair. I think it would be best if I see Mr. Mkhulu-Bethe and Mr. Duprier are online, if they take you through the amendments. I think they've been distributed to members by the committee section. Just to say where these are generally, but to make some general points or the more political points. The NCOP put the bill out for public comment, and there were submissions made by the public. We also had engagements with the Land Claims Court judges who still had issues with the draft bill, and most of the amendments, or many of the amendments, are as a result of that engagement. So the more important amendments is that the Prevention of Illegal Eviction and Unlawful Occupation of Land Act is coming out from the jurisdiction of the Land Court. That had come from the Land Claims Court judges. Currently, the High Courts deal with a lot of PI cases. You can't have the High Court and the Land Court dealing with the same kind of matters because they'll set up a different jurisprudence. And the concern from the Land Claims Court judges was that they may not be able to deal with all those disputes, PI disputes in the beginning. So we'd agreed. When I say we, it's the minister and myself that PI could come out for now. When the court is up and running, then PI can come back. So that's the one. The other is there's some transitional provisions relating to the rules and to the staff of the Land Claims Court. There is a provision which the Land Court judges wanted relating to the removal of actions or proceedings from the Land Court or any other court to the Land Court, or from the Land Court to another court. And that was basically, if somebody's come to, let's say, the Land Court and they should be in the High Court, that rather than just having to withdraw the matter and the parties have spent money, the court can order that the case gets transferred from the High Court to the Land Court, or from the Land Court to the High Court if it's in the wrong place. The one issue that there wasn't, well, there was a change, but there wasn't full agreement on, just to highlight it, was that the Land Claims Court judges wanted concurrent appointment in the Land Claims Court, in the Land Court, as they have currently in the Land Claims Court. That means they're appointed currently as a judge of the High Court and a judge of the Land Claims Court. We're wanting with, and their concern was that, and they continue with that in terms of the transitional arrangements, the existing judges of the Land Claims Court. Well, they can elect, they can elect where the two, but they can continue with that. The issue that they raised, concerned with, is that they're worried that people won't want to be judges of just the Land Court, that you may not get people. From our side as government, we're wanting a standalone court, similar to the Labour Court, where people are just judges of that court. However, taking note of their concern, what's now in there is provision, saying that a judge, person who wasn't a judge at the time of the High Court or any other court of similar status, does not automatically hold concurrent appointment of the court and the High Court, unless the JSC advises the president that such person must hold concurrent appointment. So we think that's a good compromise, in the sense that it's then left up to the JSC to decide whether a person is appointed concurrently or not. Just the say that the Land Court judges are not that happy with that. They would still like complete concurrent appointment. So, Chair, those are the main, I think, the more important ones. Otherwise, it's sort of more typos or slight additions. There was also a problem, which I think the committee is aware about, that the bill that was published was actually not entirely the bill that was approved by the committee. I think a couple of sections had dropped off, and so they have been put back. So they were actually provisions that you had supported. But if I can then ask through you, Chair, I think that it's better then to have the officials just going through each clause, although they need to do it briefly. If I can hand over to Mr. Mokolubete or Mr. Dupriya through you, Chair.
Thank you very much, Deputy Minister.
Good morning, Mr. Chair, members of the committee and my Deputy Minister. Mr. Mokolubete and I agreed that I will lead the committee through the amendments, but as always, he's always welcome to interrupt me when I start misleading the committee.
Deliberately misleading the committee.
Thank you for your kindness, Chair. I'm just going to try and screen share quickly. I want to show you two documents. The first one is sort of just a summary, and it's always nice for us if the Deputy Minister introduces a topic, because then he makes our job much easier. Chair, this is a document that indicates to you that all these amendments can be divided into two categories. The first one is those that are technical or consequential amendments, and then there are substantive amendments, and those are in clauses 8, 12, 14, 25, 27, 33, 34, and then, of course, the Deputy Minister already indicated to the committee that item 9 of the schedule to the bill will then be deleted from the bill and will not appear in the version of the bill that must be referred to the President. I'm quickly going to take you then through the bill itself, the working document. Now, once again, Mr. Chair, and I'm not really going to bore you with the technical details, but in the long title, there will be an amendment which is of a technical nature. In the preamble, there are no amendments. Then in the index to the bill, we also just affect technical corrections, and those are more of drafting requirements, one could possibly say. But unfortunately, those things did slip through when the B version of the bill was prepared by the committee for referral to the NCOP. In the clause 1, there are no amendments, Mr. Chair, as well as clause 2, 3, 4, 5, 6. In 7, we find technical amendments, if I may call them that, which are actually self-explanatory, so I don't think we need to bore the committee with those details. And even in clause 8, the amendments that are affected here, which maybe have a bit more around the bone, is then the insertion or the proposed insertion of a paragraph B to ensure that the whole issue of dedicated officials, judges, to the Land Court, but then the compromise that if the JSC recommends to the President then and a concurrent appointment, then that will be the case. Clause 9, nothing really to report to you, it remains the same, as well as clause 10 and clause 11. In clause 12, we have identified this as a substantive amendment, but it is more a question of just clarifying the qualifications of assessors, and the proposed amendment is actually then contained in the proposed new paragraph B of subclause 2. Then we can proceed, Mr. Chair, and this is also just actually a clarification on the remuneration of assessors, and I don't think we need to say much there. I think it is self-explanatory. Clause 13, there's nothing to report there. Technical amendments, as you will see in the heading to part 2. Clause 14, once again, strictly speaking, Chair, this is just a clarification of the role of the Rules Board, and then just an addition to ensure reference to Chapter Roman 3, capital A of the Restitution of Land Rights Act, and then also bringing in or confirming the existing position as to the powers of the Rules Board itself. Subclause 2 is also actually, and I don't know whether Mr. Makudubete would want or is tempted to interrupt me here, but I would also tend to argue that this is also actually a provision, although it is substantive, which is self-explanatory. Most of these amendments that have been effected up to this stage, Mr. Chair, mainly came from persons who made comments to the select committee, except of course as highlighted by the Deputy Minister regarding the proposals that have been made by the judges of the Land Claims Court, and the one is then the whole issue of concurrent appointment. This is also merely a clarification. Clause 15, there's nothing. 16, nothing. 17, nothing. Technical correction. Witness fees remains as approved by the National Assembly, as well as the admissibility of evidence. Then the next one we'll find in clause 24, and this was also a proposal by the judges of the Land Claims Court, indicating to us that the words incidental to an issue have raised interpretation problems in the past, and they proposed that the words sufficiently connected to a matter should then rather be inserted in that provision, and the department agreed with them, Chair. Then in clause 25.5, it's also mainly an issue of clarification there. That's a technical correction in clause 26. When we proceed to clause 27, the variation or rescission of orders of the court, mainly a redraft of the provision itself, with the addition of reference to matters in respect of which there's no appeal, and that would be actually the new paragraph D then. With regard to costs, nothing. Mediation was as approved by the National Assembly. Clause 30, the same thing. And Mr. Chair, this is where I need to apologize to the committee. This was a mistake that I have made. When the committee approved the A list, clause 31 and 32 were combined, and we have had it like that, and it was approved by the portfolio committee in the A list, but we were a bit under pressure to prepare and check the B list. And this, unfortunately, and I wouldn't want to blame the printer's devil if there is something like that, but I would like to imagine that I could put the blame on the printer's devil that fell out in the B list. However, fortunately, Mr. Chair, we realized that very quickly, even before the B version, the final B version was referred to the select committee. And due to the fact that the bill was approved by the portfolio committee in 22, we realized that we would have, in any event, had to make proposed amendments to the select committee for approval to be referred back to you, because then the reference to our Land Court Act in our schedule to the bill was incorrect by referring to it as a 22 Act. And then clause 32 was also approved by the National Assembly, and it's merely in order to revert to that position where the portfolio committee approved the A list. Clause 34, once again, Mr. Chair, I think this is a provision, although it looks like a bit of a long provision, it's self-explanatory, and I think the Deputy Minister summed the position up. It's just to make provision for the Land Court in those cases where a matter should actually be heard by, for example, a High Court, that it then be referred to that court, or in the High Court, the judge realizes that a case must actually be heard by the Land Court, that the case can be referred then to the Land Court. So this is actually a precautionary provision, but a necessary one. With regard to the transitional arrangements, the Deputy Minister also alluded to that, and it's mainly about the officers, the current officers and staff of the Land Claims Court, that when this act comes into operation, it will ensure that those officers and staff will then become officers and staff of the Land Court, but essentially on the same terms and conditions of appointment that apply to them immediately before the implementation of this act. And clauses 4 and 5 actually just, subclauses 4 and 5 just deals with the whole issue of clarification around the rules. And then it's merely a renumbering. And then, and with your permission, Mr. Chair, I'm not going to bore you with the detail. However, as we indicated, for example, here, most of the amendments then proposed in the schedule is just correcting the 2022 to 2023, which is then the correct reference to our Land Court. And then right at the bottom, when we get to item 9, is then, and it was also explained by the Deputy Minister, that the very strong concern was expressed that the Land Claims Court judges were concerned that they will be inundated with PI matters, where it might be more appropriate, rather at this stage, to delete item 9 from the schedule, and then, which then, when the court is in such a position where the court can start hearing these type of matters, that the relevant act just be amended to ensure the jurisdiction of the Land Court. And Mr. Chair, I'm going to allow with your permission, Chair, if there's anything that Mr. Makudubete would like to add or highlight, but from my side, I think I have covered everything that I need to cover with regard to the proposed amendments. Thank you, Chair.
Thank you, Mr. Dupré. Mr. Makudubete.
Thank you very much, Honorable Chair, and good morning to yourself and honorable members, as well as the Deputy Minister. Chair, I do not have anything to add. My colleague has covered everything that we need to address to the committee in terms of the amendments proposed by the Select Committee. Thank you, Chair.
Thank you very much, Mr. Mapulubecha. Members, any comments? Honorable Breitenbach.
Thanks, Chair. Could we just go back to the section on assessors, please? Let me just have a look at that.
My apologies, Chair. I should have kept the document on the screen. Mac, just quickly assist me. Can you just point me in which direction
check
I should
clause
go?
12, clause 12 perhaps?
Yes, thanks, Mac. There we are. I don't know whether Ms. Breitenbach would like to consider the proposed amendments in clause 12.2 or then
I just want to have a look at the whole section again, please. So,
Sure.
because I can't look at it on my own computer now because I'm looking at yours. Okay. I'll just go up a little. Okay, so my issue with assessors, and it always has been, not only with this particular piece of legislation, but always, is that assessors are paid by the state. They're paid by sort of the Department of Justice. They in that sense are not independent, and they're somewhat different to judges as regards independence, because they're not necessarily jurists or even lawyers. So I have a small issue with availability of assessors. My own experience in courts has always been that it's very difficult to find assessors, and it's very difficult to keep assessors. So they may start a trial, but then when it becomes part of it, they disappear into the ether, and you can never get them back again. And that causes all kinds of problems, and have to the matter has to be started de novo. There's also, for me, always been a blurring of the lines between, the judiciary and the state with assessors, because they're not jurists and they have, in that sense, no real independence. Is that not blurring the lines somewhat? I'd just like a comment on that, please. I also have an issue with the judge's complaint of their appointment, but perhaps this isn't the right time to raise it. Thank you.
Thank you.
On that issue of availability, I think you raised the same matter on the judicial matters with respect to the regional courts. The issue of availability, I think it came out when you were briefing us. I think it's what also partly Honorable Breitenbach is raising on this issue, that won't it cause problems if the assessors are not easily available or do not finish cases?
Chair?
Honorable DM?
No, look, this is different to what is in the existing law. I think it's the Criminal Procedure Act with the regional courts, where the accused can elect to have assessors, and then they must be had. In this case, and that's being deleted, which would then be similar provisions to here, that the court, and that would be the presiding officer, would decide whether they want assessors or not. So in this case, in terms of 12.1, the original wording hasn't been changed. The court may sit with assessors. The amendments were to clause 2, which was to specify that it's the presiding judge who appoints the assessors. So it's the court, but that court is the judge. And then just clarifying that it can be skills, experience, knowledge, etc. And then the last point was more of a technical one around remuneration. The minister must consult with the Minister of Finance. So, look, I think Honourable Breitenbach's point is, if I'd understood her correctly, she's not particularly happy with assessors who are paid for by the state. My understanding is that they're there to assist the court with expertise, that the decision is taken by the judge. It's if the judge decides that we need some, I don't have the expertise on this matter, I'd like an assessor who is a quantity surveyor, maybe, if that's the disputes over the value of the land or the borders, boundaries, that kind of stuff. So but just to stress that, it's not the same as what's in the regional court that we're wanting to abolish. It's giving the discretion to the court has a discretion. The presiding officer, presiding judge will decide on whether they feel they need an assessor. And the payment issue, I'm not sure how else one can deal with that. I mean, obviously, in terms of the Act, and it says an assessor is not in full-time employment at the state, basically because state officials would not be able to get additional remuneration. But it implies that the assessor could be somebody employed by the state. That they are entitled to the remuneration, so that hopefully protects them a bit more. So I don't know if that answers the issue. In terms of what was approved by the committee before, it is simply, the amendments simply are clarification that it's the judge who appoints the assessor. The issue of 2B, which is the skills, which is quite broad, skills, experience, knowledge relevant to the work of the court, irrespective of whether the person has any legal qualifications or not. And then lastly, the issue of consultation. It's mainly consultation with the Minister of Finance over the fee, the remuneration to be paid to assessors. So I don't know if that helps, but anyway, so those are the amendments that are coming from the NCOP. The others you'd agreed upon. In a sense, I get the sense that Honourable Breitenbach wants to redo the whole assessors issue, which I would plead not to. So I don't know if that's she's satisfied with that answer.
Thank you very much, Deputy Minister. Honourable Breitenbach.
Thanks, Chair. I don't want to redo the whole assessor thing. I've never been in favor, particularly in favor of assessors, and I think there are other ways of dealing with, a lack of experience or knowledge in a particular field. But be that as it may, my issue with the remuneration, I'm not sure how we can address it. I do understand that if somebody is not in the employ of the state, they can't come and sit on a bench for 5 or 6 weeks or even months with no remuneration. I get that. How it's to be dealt with, I'm not sure. Do assessors, can the Deputy Minister assist me in this court? Is it envisaged that these assessors will take an oath? And what would that oath entail?
Mr. Chair,
yeah, Mr. De Prier?
Mr. Chair, yes, it is envisaged that they should take an oath, but it's going to be a prescribed oath. So yes, that is something that has to receive attention. And I could maybe possibly just to add to what the Deputy Minister has said, maybe just emphasize to the committee that assessors will be appointed not to decide questions of law, but questions of fact. So that provision is there, or the clarification is there. And then sub 5 is also important to the extent that the judge or judges who appointed, for example, 2 assessors and 1 assessor, for example, passes away, the court then does have a decision or a discretion to either proceed with the remaining member of the court or then to start afresh. So the provision there, the discretion has been provided for. Thank you, Chair.
Thank you. Do they decide on the questions of fact, or do they advise the judge on the question of fact?
Thank you, Chair. They actually advise the judge on questions of fact. And provision is also made that if you want a single judge, or the paragraph B here is quite clear to indicate that when they decide on or advise the court on questions of fact, the judges still have the prerogative to either accept or not accept. Thank you, Chair.
Thank you very much. Honorable Breitenbach, are you fine?
Chair, semi-fine. I would like the department to just give some thought to how the oath should look in order to ensure, as far as that's possible, the independence, the independent approach of assessors, so that they don't form the view that they need to dance to the tune of their paymasters.
Okay. So at some point when the prescribed oath is done, you would want the it is, we're also furnished with that particular oath so that we can have a look at it, is what you're saying.
Well, that would be ideal. Thank you, Chair.
Thank you very much. Any other issue, members? Sorry, I can't see. Okay. Are we fine with the recommendations, also the proviso that Honorable Breitenbach has suggested with respect to the oath, the prescribed oath? Can I have guidance, members? Do we support the recommendation, the amendments from the NCOP?
Okay, we have no difficulty with the amendments then of the NCOP. It's fine.
Thank you very much. Any contrary view?
We support, Chair.
Thank you very much. Can we, I think next week, Tuesday, then we will adopt the report on these amendments, which will go to the House as soon as possible. Can I take this opportunity to thank the Deputy Minister, Honorable John Jeffrey, Mr. Mapulubete, Mr. Dupree, for taking us through the amendments from the NCOP in an able way. Thank you very much for really coming to this meeting and assisting us. Thank you very much.
Chair, thanks as well, and thanks for the committee dealing with the bill. Finalizing the bill. Just to ask that if it can be passed in plenary before the National Assembly rises, I think it's 2 more weeks. That would be good, because it gives people the time to. It gives the department then more time to set things up. So if it is possible, and if Honourable Breitenbach, obviously the majority party will go for it, but if Honourable Breitenbach could also lobby her chief whip over it. I think that return bills generally don't have debates. But thanks, Chair.
Thank you very much. I think Honorable Breitenbach has taken note of that, but she was the mover for the adoption of the bill, which clearly she has no problems.
Chair, just because I say I'm fine with it doesn't mean I'm moving for the adoption. Don't misunderstand.
Oh, okay. No, that's fine. So I think DM, just before we allow you to do your other issues, I think if we can just, before we move to Ms. Silkstone, just to say that we have been advised that the department is not yet ready with the cannabis bill. You still need some time, which we have no problem in giving you enough time, so that when you come back, you bring something that is worth of being considered. So is it possible that you would come back with the responses from public hearings before adjournment, or you still need more time to go through those responses? So I'm asking this question because we would need to redo the program for the remaining 2 weeks.
Chair, I think it's more for the department. I mean, Mr. Dupree is also involved in the cannabis bill. I think, I'm not sure about Mr. Makulubete, but I think it's more for Mr. Dupree to say when he's ready. I think that the bigger issue is not, well, is working out what to do with the bill. We introduced a bill that complied with the ConCourt order. There were pressures from the public to extend it, and now it's in a more complicated position. I'm actually wondering whether maybe if I smoke some cannabis, I'm not a cannabis smoker, maybe if I smoke some cannabis, maybe there will be solutions that become apparent. Maybe if we all smoke cannabis, including you, Honorable Breitenbach. Yeah, but can Mr. Dupree just respond about readiness?
How's your Yiddish? Do you understand Yiddish?
No, I don't, Honorable Breitenbach. But if you're going to say if you're going to swear in Yiddish, other people, it may not be appropriate.
You're very well aware of the fact, Mr. Jeffrey, that I never swear.
I'm not sure, Honorable, that Mr. Dupree, I must just advise you that before you respond, be careful with your response, because I think last time you asked for an extension. I think it was based on the pressure to want to come back to the committee. So you asked that we should give you Wednesday, you will be ready on Friday, and you were not. Quite clearly, there is a possibility that you might have underestimated the magnitude of the work that needs to be done. So when you answer this question now, don't overestimate nor underestimate the amount of work that needs to be done.
Thank you, Mr. Chair, and thank you for the advice. I would have in any event approached it like you advised. Chair, yes, we caught up with a bit of technical issues, especially with regard to the comments that were made by the most recent public submissions. That prompted us, or we realized that we need to beef up our summary, but then we also realized that we must have some important internal meetings, which also included consultation with a very important external stakeholder. We were not able to conclude that meeting or get to a final point where we would be satisfied with the questions that, or the answers to the questions that we have raised, Mr. Chair. And this is the first time for me personally working with the committee that I need to give you bad news, Chair, and please accept the fact that I honestly don't like doing this, but I don't think we will be ready within the next 2 weeks. And I personally, Mr. Chair, and this is not even on behalf of the department, but I do it on the behalf of the department as well. I apologize to this committee. This is really the first time in my career working with this committee that I have to indicate to you that we are not ready at this stage. You will recall that there were concerns expressed already about the constitutionality of the bill, and that's not an easy task, checking it and going through everything. And then, of course, one also is a bit divided now between a couple of bills. Well, actually, I think it's 3 of them at the moment running simultaneously. So my time, it's becoming an issue, but we will be ready for the committee when the committee convenes after the recess, if we may plead for your indulgence, please. Thank you, Chair. I don't know whether Mr. Makudubete would like to add something, because he's also involved in that bill. But Chair, thank you very much.
Mr. Makudubete?
Yes, thank you, Chair. And I do share the sentiment of my colleague, Mr. Dupree, in as far as the work that needs to be done is concerned in relation to this bill. I do agree with the chair that we might have underestimated the work that needed to be done in relation to this, especially emanating from the comments that were raised during the public hearings over the period of 2 days last week. Those indicated that there's more work that needs to be done than what we thought, and we do really request that we be indulged in that regard. Thank you, Chair.
Thank you very much. Members, I think we should grant them their wish. I mean, it's a complex bill. The issues that have been raised, they're quite complex. I think it's better to deal with a properly considered bill than to push them to bring something that will make us to do much more work, because we'll end up spending the same amount of time that we should have just given it to them to do the right thing. Honorable Jelle.
Good morning, Chair, and good morning, DM and the team, members. Chairperson, I think I'm going to agree with you on this one. That the session, the last session when we were getting those public comments, it really indicated to us that this is not a simple job. It is very complex. And I think it will be fair, Chair, if we really give them that time so that they can be able to go through all the submissions and to be able to check them as you indicated, as they also indicated. I think it can only be fair, Chair, to grant them that extension. Thank you, Chair.
Thank you very much. Any other comment or a contrary view? And none. But it means that members, the next term will be a bit difficult for the committee, because it means that in the next 4 months, when we come back after recess, we will be dealing with 7 bills. that would need to be concluded at that time. If all the bills that we were informed that they are a priority are to be submitted, noting that the sex crimes bill would not be coming, but if we have to count the 2 bills also for correctional services and the other bills for justice, it would mean that we will have to do legislative drafting in the morning and in the afternoon, and also deal with the BRRR processes. So it's not going to be a very easy time when we come back. But there is nothing else we can do. The bills are not yet ready. Some of them have been, we have received them, and some of them were waiting for them. So the bills that would be with us by the 30th of June are the bills that we will be able to process. Deputy Minister?
Chair, I just wanted to ask if time is coming on your program now because of the cannabis bill. The Judicial Matters Amendment Bill, I'm not sure how many submissions were received from the public and whether there were in fact submissions, but if there weren't many or if, and I don't know if you want to have hearings, but maybe we could look at, or the committee could look at work on the Judicial Matters Amendment Bill if it's got time in the next 2 weeks.
No, not this. How many submissions did we receive, Committee Secretary? Because we had not done that work, because we had reserved the time to deal with the cannabis bill. Committee Secretary?
Chairperson, I'm just quickly checking, but I think there were less than 5.
Yeah. But still, it would not make a difference, Honorable John Jeffrey. It will be just say we will be left with it's just Tuesday, Wednesday, Friday next week, and then the week that we are closing. It would not really, we'll still be having this difficulty of having to process too many bills when we come back, which we will have to address it through our program for the coming terms, for the coming term.
Yeah, Chair, it was just that if there's nothing contentious being raised on judicial matters, which hopefully is the case because it's meant to be a non-controversial bill, maybe you can finish the bill before the House adjourns. That was why I was asking, but maybe we can look at I mean, I haven't seen the submissions. I don't know what they are. Maybe that can be looked at, but I would have thought if there's nothing controversial, you may be able to finish that bill.
One will have to check whether there are any people, which I think there are, who would want to make oral submissions, and we must also give them reasonable time. We can't say next week, Monday, you must come. So we will look at that before when we do the revised program. Any other matter on this issue? Thank you very much, the Deputy Minister and the team.
Thanks, Chair. Thanks, honourable members, and a special goodbye to Honourable Breitenbach.
Honourable Breitenbach.
Say that again, my dogs are barking. What's the problem?
A special goodbye to you.
Oh, thank you so much. I love being made to feel special. Thank you.
Thank
Your
you very
special
much.
Honourable Breitenbach. Goodbye. Thanks, Chair.
Thank you very much. Ms. Silkstone.
Yes, I'm here. Banani, would you be able to share the presentation, or should I try? Let me see. Ah. Okay, and then I need to go up here, sorry. Just need to go to slideshow. Okay. Sorry, I've got, there we go. Okay. Okay, so this isn't a very long presentation because we're quite familiar with the process. But just to quickly run through. Sorry, Chair, is it okay if I go ahead?
Sorry?
Is it okay if I go ahead?
Yes, please.
Okay. As we know, there's already a vacancy at the commission after one of the commissioners resigned, and then there was another letter from the chairperson of the commission just informing us that that there will be vacancies coming up when the terms of office of 5 of the commissioners expire at the end of the year. So in short, we are looking at filling 6 positions. 4 of these are full-time and 2 are part-time. And then I'll just make a note about that the chairperson has also asked that we consider consider filling all the vacancies in a full-time capacity on account of the workload of the commission. Sorry, my mouse is now not working properly. Okay, so I've covered that already. So the point of this thing is we have the commission consists of 8 commissioners. What we're sitting at the end of the year is there will be only 2 left. That's for Commissioners Chohan and Intuli. They were appointed in July 2021, and therefore their terms of office will only expire in 2028. So they will be the commissioners that will provide continuity within the commission. In terms of the qualifications, the constitutional criteria are simply that the commissioners must be South African citizens and they must be fit and proper persons. And then they should also comply with any other requirements of national legislation. And then section 1932, sorry, gone too far ahead. Provides that the commission established by Chapter 9 must, that a commission established by Chapter 9 must reflect broadly the race and gender composition of South Africa. Then, if we turn to the actual Act, the South African Human Rights Act, Commission Act, it highlights the need for independence and impartiality. So that's highlighting that the commissioners should have those criteria when they're appointed. The specific statutory criteria are that the 2 constitutional requirements that they must be South African citizens and fit and proper persons, and they must have a record, and these 2 are new, have a record of commitment to the promotion of respect for human rights and a culture of human rights, and be a person with applicable knowledge or experience with regard to the matters connected with the objects of the commission. So they, as you can see, the requirements are very wide. The disqualifications are probably longer than the qualifications. Sorry. They must be appointed by or may not be appointed if they are in the service of the state and receive remuneration for that service. They are an unrehabilitated insolvent, declared to be of unsound mind by South African court, convicted of an offence and sentenced to more than 12 years imprisonment, but without the option of a fine, either in or outside South Africa. An offence office bearer or staff member of a political party, member of the National Assembly, a permanent delegate of the National Council of Province, a member of a provincial legislature, a member of a municipal council, or who is on a candidate list for any of those positions. I think in one of our previous rounds of appointments, there was somebody who was an office bearer in a party. In terms of the appointment process, it's the one that we're very familiar with. The National Assembly must recommend persons who are nominated by a multi-party committee of the Assembly, in other words, the committee, and approved by the Assembly by a majority of vote. And the National Assembly makes a recommendation to the President, and the President appoints. And then this is the important thing. They are appointed for 7 years. Sorry. Oh, I don't know what I'm doing here. Sorry. I'll just talk to it. They're appointed for 7 years, and it is renewable for 1 extra term. So there are commissioners there. In fact, all of them are eligible for reappointment. And then and then the last slide are just the things that we consider. And those are at the full-time, those part-time request of the chairperson, the number of candidates who want to shortlist, the timeframes that are involved, bearing in mind our parliamentary program that will happen before the end of the year, the public participation process that takes place, and screening. Those all kind of factor into how much time we need for this process. Then we look at the things of the structure and the length of the interviews. We can probably discuss that later. And then interview questions. So those are, yeah, so that's just the end of my presentation.
Thank you very much, Ms. Silkstone. Members, any questions or comments? None. 2 issues that I must bring to your attention. In fact, it's 1 issue. 1, it's the decision that we must make here. And another one, I think it's something that we must also take into consideration when we deal with this issue, or when we deal with the program for the next term, that some members, I know Honorable Breitenbach, Honorable Horn, myself, Honorable Janji, we have been appointed to, or recommended, let me say recommended, to serve in the ad hoc committee that would be interviewing the public protector. That is going to be taking place between now and end of, I think, August. We are supposed to report back by end of August. So that is the additional work that we would need to consider. And then the other issue, I think, which is a decision that we need to make, is the request that has been made by the chairperson that we consider having all commissioners to be full-time. The current situation is that you have six full-time members and 2 part-time commissioners. And the reason for that was that with the part-time commissioners, you were meant to be dealing with a particular technical skills, but in a situation where a person having that skill might not be willing to be full-time. For instance, maybe you're dealing with a professor of immigration or of constitutional law who would not want to leave his or her full-time employment at the university, but who's willing to come and assist to the commissioner. That was the reason why we in fact, the law is crafted in the manner it is crafted, that you have part-time commissioners and full-time commissioners. Now, the request by the chairperson of the commission, speaking on behalf of the commission, is that all positions should be full-time. That is the decision we need to make, which is linked to this process, because the advert that must go out must indicate that whatever decision we take, whether we agree with the 8 being with the 6 being full-time now, all of them being full-time, the advert must go out like that, or if we agree on the current situation where we're full-time and part-time. So that decision is very important. Members, any views?
Chair, what is it up to us to decide whether the members will be, if all the members will now be full-time or not?
I think it's for us to decide, because we must the advert must indicate, if, for instance, we say we issue an advert and we want 6 full-time members and 2 part-time members, so that a person can know whether he wants to be full-time or she wants to be part-time. Or if we say all of them are full-time, then a person who does not want to be full-time would not need to apply. So it's for us to decide.
Okay, thank you.
Thank you. Maybe before I go to Honorable Velman, Honorable Maseko, Honorable Ms. Silverstone, is there anything that you want to add or subtract?
I just wanted to just say that there would be funding consideration. So that would, in making the recommendation, we would have to make sure that the funding is available for that.
Thank you. And it is not available. Honorable Nuvot Rohan.
Thank you very much, Chairperson. Good morning to everyone on the platform. Thank you to Ms. Silverstone for, well, actually, Ms. Silverstone took the words out of my mouth. The funding, we don't know. I mean, they said, or like you said, Chair, there is no funding. So how can we make a decision, for another 2 commissioners to be full-time? It hasn't even been considered. So I think it makes it difficult for us to agree to go ahead making 8 of them full-time. So I think we do need to know if there is funding available for that, if we can make that decision. And then secondly, I wanted to make sure the advert for this has not gone out yet, because you said that there's another public protector ad hoc committee which needs to be completed by the end of August. So now my next question was going to be, if the adverts are still going out, when will be the deadline for those adverts? Thank you, Chair.
Thank you very much. I think once we are done with this discussion, we'll go back to those operational matters. When is the advert going out? What time do we give for people to apply? All of those things, I think we'll go to those nitty-gritties. So the advert is not yet out. Honorable Maseko Chele.
Thank you, Chair. I think Chair, Ms. Silverstone just covered me. And even my other colleagues covered me, Chair. That was my concern as to, do we have money? Because it was last time when this issue was introduced, those issues were raised. So I think I'm covered. I'll just listen to your response, Chair, on those ones. Thank you.
Thank you very much. Honorable Silverstone.
Chairperson, I just wanted to, when we appointed when we passed the Human Rights Commission, the South African Human Rights Commission Act in 2013 or 2014, we increased the number of commissioners altogether. And at that stage, what the committee did was they engaged with the Minister of Justice, and I think the Minister of Justice then engaged with the Minister of Finance. So that would, if we wanted to find that would be the process that I would imagine that we would need to follow if in terms of funding, if we went down that route. Yeah, so that's all I wanted to add. There was one thing that I did leave out in my presentation, is that the committee is also responsible, the National Assembly is also responsible for recommending the chair, or for basically making the recommendation around the chairperson and the deputy chairpersons of the commission. So I just bear that in mind, that when we do our interviews, that we'll also be looking to making a recommendation around the chairperson.
Okay, thank you very much. Members, it's unlikely that we would have, even in my engagement with Deputy Minister, that there is budget for this issue. I would recommend that we stick to the present situation where we have full-time commissioners and part-time commissioners. We don't depart from it, because we are always saying that we must do more with less. So we should not, in a manner that is not properly motivated by ourselves, even to Parliament, to the National Assembly, just increased the cost of doing business. So I would suggest that we stick to the present situation where we have full-time commissioners and part-time commissioners. Would that be in order, members?
Probably, thank you.
Thank you, Honorable Masego Chele.
Yes, Chair, I agree with you. But also, Chair, I think we need also to find out exactly what is it that made them to make that recommendation, look into those issues around, in fact, as we go on, Chair, because, yeah.
No, their recommendation is that the current part-time members are working more as full-time, they're always available, which is not a good enough reason.
Thank you, Chair.
Thank you very much. Then I think let's come to Ms. Silkstone's question and Honorable Nivot Tuhan. If, let's say, we issue the advert, it must be for how long? Because the term of the commission, I think, is 31st December. We would have end of, in fact, mid-June to end, I think, 31st August as a recess. So how long should it be? Should we give it 1 month? How long we must bear in mind that also Parliament has got a procurement process especially for the media outlets. I think what we need to bring to the committee is just a decision whether we must advertise for 4 weeks or for 3 weeks or for 1 month. And then other issues, I propose that we leave them to myself and the Secretariat. I think there will be too administrative to concern the committee with those issues. I think what we need to agree at a principal level is that how much time do we give members of the community to apply for?
I think a month is fair, Chair.
1 month, okay. And then I think we will take it.
Chair, 1 month, Chair.
Thank you very much. And then we will take it from here. We'll be responsible for issues to interact with Parliament, issues of procuring the media outlets and all of those things. Then I think the other issue that Ms. Silkstone raised was the issue of chair and all of those things. I think that one we will discuss it after we have, I think, shortlisted to say how do we take the process forward from there.
That's
Will
fine.
that- Yeah, okay, that will be in order. So we would, then the other issue, which is not related to this issue, which I would ask a permission of the committee to give me the authority, that when the bills come in the middle of the recess, when they come, for instance, the bill relating to jigs and all those bills, that we do not wait for briefings. We use the recess period to advertise for public comments. And then when we come back, then we can get briefings, and then, but at least would have saved time of public comments. Will that be in order?
I
Fine, Chair.
support that.
Thank you very much.
Yes, supported, Chair.
Thank you very much. That is taken care of. Any issue that would like to raise, Ms. Silstone?
No, I'm covered. Thank you.
You're covered. So I think the last issue, members, I think is under any other business because it's not reflected here. The recent developments in as far as cannabis bill is concerned really do necessitate that we have to rework the program for the next 2 weeks. So we will make a proposal to yourselves by Tuesday. We will have developed a draft program for the remainder of the 2 weeks. Will that be fine?
It's absolutely fine. Thanks, Chair.
Thank you.
Fine, Chair.
But that issue that was raised by the Deputy Minister, I just wanted it to be considered by the committee, not being influenced by the executive, because it was going to not send a good precedence. Should we consider dealing with these judicial matters now, or should we deal with it when we come back? Because the issue is that we must look at whether there are people who would want to make oral presentations. Because the fundamental issue is that there must never be a shortcut in as far as public participation is concerned. It was going to compromise the process of our lawmaking. And in doing that, we must give adequate notice to members of the public so that they are able to prepare. And if we decide, for example, to have a virtual or a physical public hearings, that must be factored in the planning. That affects the amount of time you should also give it to them. Some members of the public might not have resources, like they can buy a ticket tomorrow and come to Cape Town if we say it's physical. Even some of them who might think, myself and Nivot Duchen, data bundles are not a problem, but for some NGOs, they need to collect money to buy data bundles for 100 rands. So those are the issues that we must always bear in mind, that we should be giving them adequate notice. We can't just, because we are under pressure, then it amounts to malicious compliance. Honorable Breitenbach.
Thank you, Chair. I agree with you absolutely, and I don't think we should compromise the process. And I don't believe that we will be able to deal with it in such a short space of time and give adequate access to the public.
Thank you very much, Honorable Nivot Duchen.
Thank you, Chairperson. Also keep in mind that if we do tell people, like NGOs to come tomorrow, the next day tickets are expensive. So we also need to give them ample time to purchase tickets before they come. So it's not only about the date, but also the price of getting here.
Yes. Also the content, they must prepare the content because public hearings must be meaningful. So they must be adequately prepared. So they have to do, if they need to do research, they must be given enough time to do their research. So this is how we must, is our understanding of the various Concord judgment on public participation. It's not just a compliance issue. It's part of a core democratic value that we must always uphold. So thank you very much, members. I think that is that.
My hand was up.
Oh, my apologies, Honorable Chair.
Thank you, Chair. No, I understand. No, my question was that, Chair, I think, sorry, it was on the issue. There's a recent judgment about the issue of public participation that made me to think really deeper into this. I'm not sure. I did hear some comments on the TV about that, but I wanted to find out, Chair, because we are now talking about also the involvement of some money for people to come to us in terms of that. What about these people that they can't even have money to buy tickets to come here? I understand that one of raising it's possible, but there are those NGOs that they can't even be able to raise those. So I'm not sure if maybe I don't want us one day the issue is taken to court and we are being told that maybe we're not able to reach even those who are not reachable. For example, take those who are staying in the rural areas, those who can afford that amount. I wanted to find out I know what the kind of audience that we are dealing with, but how do we cover those? I don't know. Thank you, Chair. It was just a consent on my side.
No, thank you very much. Well, it's a bigger issue that Parliament has to grapple with, because that is it has got serious financial implication even for Parliament, and that is why for highly charged bills, some committees, even this committee some years back, we would go to provinces and to certain local municipalities for public hearings. I don't think we are there where you, where you are. You want us to go, Honorable Chair, and I think all of us are working towards that, where public participation is a real meaningful public participation, not only for people who can afford, but people who would want to engage with Parliament. And we think that some of the lessons that must be learned out of COVID, and I think we have seen even with some of our public hearings and some of the people who have made inputs, that even through this thing of virtual public hearings, generally people who might not have had the means to come to Parliament, the virtual hearings have made it much cheaper for them to make representation. That is why you have such a high number of organizations, not a high number, but a reasonable number of community-based organizations making inputs on the Cannabis Bill. But it's something that generally Parliament as a whole needs to factor it in their budget, because we were once briefed in one of the meetings of chairs and whips that there's a committee that tried to go to each and every district, and for that one public hearing for that bill, it was more than 12 million rands. So it's still a complex discussion that needs to be engaged upon. But that's why it's important that the we try by whatever means possible to ensure that we act in the most rational way in ensuring that people who have shown interest in making presentations, we give them adequate time to come, even to use the recent means like a virtual means to reach us. But I think it's going to be work under, and it's going to be work under progress for many years to come. And I think on that note, members, I think let's introduce the new whip of the ANC, Honorable Maseko Jele, is taking over from Honorable Janji, who has been elected chairperson of monitoring and evaluation. And then Honorable Paul Ngola has been elected, but is also going to be redeployed to another committee, Constitutional Review Committee. We would like to welcome Honorable Jele, who has been part of us since 2019. She knows how we work. She has been part of every meeting of the committee.
Many congratulations, and congratulations to the other two as well.
Thank you very much. Thank you very much, Honorable Breitenbach. I think, members, that brings us to the, okay, can we, there is
Just remember, Chair, that Honourable Maseko Jele is the ANC whip. She's certainly not the DA whip.
That is what I said. I said ANC.
No, this time, Chair, I'm a whip or two.
No,
Yes.
no.
Yes, the leader of the DA in the National Assembly is called the leader of the opposition, and the chief whip is called the chief whip of the opposition. So maybe Honorable Jele is going to be the whip of the portfolio committee, whipping Honorable Breitenbach in particular.
Let me know how that worked out for you.
Members, thank you very much. We will meet on Tuesday.
Thank you, Chair.
Bye.
Bye-bye.